Commission's Administrative Meeting for
Chair, turn your mic on.
welcome to the Maryland Public Service Commission's Administrative Meeting for April the 25th, 2018. Let's begin with our draft minutes from the April 18th meeting. I'll actually ask someone to make a motion on that.
Mr. Chairman, I move we adopt the minutes from the April 18th administrative meeting.
Is there a second?
Second.
All those in favor signify by saying aye. Aye. Draft minutes are adopted. On to our administrative agenda.
Mr. Chairman, before we begin, we're going to defer two items to a future administrative meeting. They're items number 16 and 17. They're from filings from Washington Gas Light Company regarding their STRIDE filings.
Okay.
First item on the agenda, item number 1, is Motorola Solutions filed a notice of acquisition completion and name change.
Good morning, Chairman, Commissioners. Janice Flynn for item number 1. Motorola Solutions has filed notice that on March the 7th, 2018, it completed the acquisition of Plant Holding Inc. and the indirect control of its wholly owned subsidiary, Airbus DC Communications. The Commission approved the acquisition on September 27, 2017. In addition, Airbus DC changed its name to Vesta Solutions, Inc. on March the 9th. The Commission granted Airbus's request to de-tariff services effective November 21, 2017. The company currently does not provide service in Maryland and has no Maryland customers. It has updated its online pricing guide to reflect the name change. Staff recommends that the Commission note the name change.
Thank you. Any questions for staff? If not, do we have a motion?
Yes, Mr. Chairman, I move we note the name change.
Is there a second?
Second.
All those in favor signify by saying aye.
Aye.
Motion carries.
Next item on the agenda, item number 2, is the State of Maryland Department of Information Technology filed a request to maintain the current Universal Service Trust Fund surcharge.
Janice Flynn again for item number 2. This item is the annual filing from the Maryland State Department of Information Technology, DOIT, certifying the cost of the Maryland Telecommunications Relay Service, the purchase of specialized equipment, and the senior call check programs. The Maryland Telecommunications Relay Service provides a dual-party relay service which allows individuals with hearing and speech impairment to communicate via the telephony network. DOIT is also responsible for administering the portion of the program that provides eligible participants with specialized telephone equipment and tablets. In addition, beginning with fiscal year 2019, the Department of Aging is required to establish and administer a senior call check service and notification program, which is also funded through the Universal Service Trust Fund. The Commission is required, pursuant to State Finance and Procurement Article, Section 3A 506D2, to set the amount of the universal surcharge necessary to fund these programs. Staff has reviewed DOIT's projections for 2018, as well as its program costs and the current surplus, as well as projected surpluses for FY 18 and 19. Staff has concluded that if the surcharge remains at the current 5-cent level, even with the higher than estimated cost for the senior call check program, the projected surplus for both FY 18 and 19 will remain healthy, and that no change is needed to the surcharge. Staff recommends that the Commission keep the surcharge at 5 cents.
Thank you. Let's first go to questions for staff.
Mr. Chairman, I have a question, but I'm not sure who it's for yet, so.
Okay, well, why don't we do this? We'll hear from representatives from DOIT, I believe. We'll be here. And then we'll see if it should be for staff or DOIT. Yes. Good morning.
Good morning. As always, it's a pleasure to be here before you all.
Could I just ask you?
My name is Brenda Kelly Fry, and I am the director of the Telecommunications Access of Maryland in the Department of Information Technology, which is a very huge mouthful. So we were recommending that the surcharge remain at 5 cents per account. It was changed several years ago from per line to per account when we added VoIP and wireless to pay into the fund.
Thank you, Mr. Chairman. I I noted that staff, and it's a very helpful buck sheet, put a chart in there that shows the reserves in the fund and the expenditures coming out of the fund, and it shows over time how they're moving. And it looks like in 2018 to me that the decrease in the reserve is accelerating.
It is.
At a very high rate, it looks like compared to previous years, and the increase in expenditures are increasing at a very high rate, which has been relatively flat for many years. And
It is.
so I'm wondering, okay, what's causing this increase in expenditures, decrease in reserve fund in the fund? What's going on out there? I'm just curious.
Okay, well, the increase in expenditures is because we now have taken on the responsibility to pay for the senior call check program, which was signed into law last year. The fiscal note actually mentions that it was $150,000 per year for the next 5 years, which is not the way it is estimated to be. It's roughly $1.2 million. So the expenditures are going up. We also have the tablet program, which is taking off, which is bringing people into the 21st century of communications, which is portability. In the past, deaf people and hard of hearing people were tied to landline phones. Yet you and I had the luxury of being able to make a phone call as we're at somebody else's house. And now with the tablet program, this is enabling them to make phone calls when they break down on the side of the road and so forth. And revenues are dropping because landlines are also decreasing.
Okay, I understand both, and it makes sense to me. I asked only because I wanted to understand
Yes, and
what the future looks like and what we may expect probably
Right,
next
and-
year if these trends continue.
And we know that we can always come to the Public Service Commission if we find that we are in, financial straits and we need to increase that surcharge. We know that. But, having a surplus also makes you a target for other entities. So we want to get off of the radar.
Got it. I appreciate that. I watched that operate for many years. Thank
Right.
you. I appreciate this. This is a great program.
Just
and
being candid here, right?
Great program, and I very much appreciate DeWitt's
Thank you.
work in that
Thank
area.
you.
So,
Okay, saying that the tablet program will bring people into the 21st century, that's a sensitive issue right here on the bench. So,
Oh,
between Commissioner Ritchie.
I'm not mentioning any names.
in what
A
way?
little more 21st century up here, but I did just have a question. It looks
Sure.
like if I read the buck sheet and the law correctly, there is a cap of 18 cents. Is that correct?
That's correct.
And as you pick up the new program, the senior call check program, I assume that you're kind of looking to the future, and is there going to be enough funds? Are you going to maybe need to start ratcheting this up a little bit so that you can have this buffer of the surplus and still make sure you keep that 18-cent?
Okay, well, looking at my program, the ones that I run, we have sufficient funds at this point. Adding into the expenditures, the senior call check, they have a cap of no greater than 5 cents per account being raised. So that would be 10 cents if we were to increase it. So I think we're okay at 18 cents. It gives me a buffer there to move up in case the feds give us the responsibility to pay for the services that they currently pay for, which is internet-based relay services. This is something that I've brought to your attention year after year. I feel like Chicken Little, the sky is falling, the sky is falling. The sky might have a hole in it right now because they have required individuals to register their home address along with their phone number to use the internet relay services. Now they can identify the originating and terminating numbers and the locations of such so that they can now turn over the cost of intra-state relay services to the states. The feds up to now have been paying for it for the last 10 years. Thank you, federal government. But now they have a mechanism where people have to register, and once they've registered, now we have the originating and we'll have the terminating phone numbers, so the possibility is stronger now that the cost of that intra-state could come to the states.
Okay, great. Yeah, generally we like to adhere to the principle of gradualism. We don't like to see rates fluctuate
Right.
wildly. For the most part, this is a
We're not.
fairly minor, overall charge. But,
Right.
Anyway, no, I appreciate the
Thank
answer.
you.
Thank you.
Okay, anything else?
Mr. Chairman, I wanted to thank Ms. Ward for the analysis on this. It was very helpful and very concise. I thought it's not something we deal with every day. So.
Right. Thank you.
Yeah, very good. Thank you, Ms. Fry.
Thank you. We'll see you next year.
Very good. Do we have a motion?
Mr. Chairman, I move we grant the request to maintain the 5-cent Universal Service Trust Fund surcharge.
Is there a second? Second. All those in favor signify by saying aye.
Aye.
Motion carries.
Next item on the agenda, item 3, is Dark Fiber and Infrastructure LLC filed an application for operating authority to provide facilities-based and resold local exchange service.
Good morning, Chairman and Commissioners. Peter Wolson on behalf of the staff. Pursuant to Public Utilities Article Sections 2112, 2113, and 8403, Dark Fiber has filed an application seeking operating authority to provide resold and facilities-based local exchange services. Initially, the company will provide local intrastate telecommunications service in Maryland to business customers with the potential to expand to residential customers. Staff has reviewed the application and determined that it meets all requirements to grant authorization as requested. Accordingly, the staff recommends the Commission grant the requested authority and grant the requested COMAR waivers in Waiver Group C.
Any questions for staff? If not, good morning.
Good morning. Rob Gassner here on behalf of Dark Fiber and Infrastructure LLC.
Any questions for the company? All right, if not, do we have a motion?
Yes, Mr. Chairman, for item number 3, I move we grant the company's request for authorization to provide resold and facilities-based local exchange telecommunications services in Maryland and grant the company the requested COMAR waivers in Waiver Group C.
Is there a second?
Second.
All those in favor signify by saying aye.
Aye.
Motion carries.
Next item on the agenda, item 4, Maryland Water Service, Inc. filed its Pinto and Highland Estates water cost and consumption data quarterly report and its unaccounted for water surcharge reconciliation.
Good morning, Mr. Chairman, Commissioners. Kenneth Albert on behalf of staff. This item addresses the annual cost true-up filing by Maryland Water Service in connection with the recovery of the cost of unaccounted for water, which I'll refer to as UFW, for the MWS water distribution systems in 2 different communities in Allegheny County, Pinto and Highland Estates. To recover the cost of unaccounted for water, MWS requests authorization to implement a volumetric charge of $1.12 per 1,000 gallons for Highlands Estates and a one-time credit of $27.71 for each Pinto customer. The MWS tariff authorizes MWS to flow through the cost of the water supply that they buy to serve their customers, including the UFW. A settlement approved by the Commission in 2016 reduced from 20% to a new level of 15% the allowable monthly unaccounted for water surcharge that's baked into the rates. And again, this is corrected in the annual true-up filing, so there's no under or over recovery. Staff's comments note that the majority of the UFW that occurs within the company's water systems is due to the loss of water from pipe breaks and leaks. The comments also point out that all water systems experience loss of water from the pipes, with older systems typically experiencing more loss than newer systems. In its comments, all staff also notes that the UFW percentages at or below 20% are reasonable for an older, well-maintained water system such as Pinto and Highland Estates. Staff is satisfied that MWS is adequately responding to the levels of UFW on its system. Therefore, staff recommends that the Commission grant the request by MWS to implement a 12-month volumetric surcharge of $1.12 for Highland Estates and a one-time credit of $27.71 for Pinto customers. And we ask the Commission to accept filing the proposed surcharges effective May 1.
All right, thank you. Questions for staff on this item? If not, I want to thank Mr. Patterson and Mr. Sushko for your very thorough analysis. It's always good to see you, Mr. Sushko. We don't get to see you that often at the AM, so it's good to see you. With that, do we have a motion?
Yes, Mr. Chairman. I move that we authorize the company to implement a 12-month volumetric charge of $1.12 per 1,000 gallons for Highland Estate customers and a one-time credit of $27.71 for Pinto customers, and accept the tariff revisions for filing with an effective date of May 1st, 2018.
Is there a second?
Second.
All those in favor signify by saying aye.
Aye.
Motion carries.
Next item, item 5, is First Energy Solutions Corporation filed a notification of material change of business operations.
Good morning, Chairman, Commissioners. Michael Dean on behalf of staff. Item 5 is a filing by First Energy Solutions Corp. notifying that it has filed a voluntary petition for relief pursuant to Chapter 11 of the U.S. Bankruptcy Code. First Energy Solutions is licensed as an electricity supplier in Maryland under Comark 20.51.0301. An electricity supplier is to file notice within 10 days of any material change, which in the regulation includes filing under Chapter 10. As discussed in staff comments, First Energy Solutions indicates that it intends to continue performing under its Maryland contracts and does not anticipate any changes in its service to Maryland customers as a result of its bankruptcy filing. Staff recommends that the Commission note the filing.
Thank you. Any questions for staff? If not, do we have a motion?
Yes, Mr. Chairman, I move we note the filing.
Is there a second?
Second.
All those in favor signify by saying aye. Motion carries.
Next item, item 6, is Compass Energy Gas Services filed a request to withdraw or abandon its competitive natural gas supplier license.
Peter Wilson on behalf of staff. Pursuant to Comar 20.51.03.05, Compass Energy seeks to discontinue its authority to supply natural gas in Maryland and cancel its license. As previously noted by the Commission, the company merged with Constellation New Energy Gas Division in August 2017. Consequently, Compass Energy no longer does business. It has no customers, no outstanding complaints, and no outstanding commission assessments. Staff has determined that all applicable requirements of the regulations have been met in order to cancel their authority. Accordingly, staff recommends the Commission rescind Compass Energy's authority to operate in Maryland and cancel its license to operate as a gas supplier.
Thank you. Questions for staff? If not, do we have a motion?
Mr. Chairman, I move the Commission cancel the company's license to operate as a natural gas supplier in Maryland.
Is there a second?
Second.
All those in favor signify by saying aye.
Aye.
Motion carries.
Mr. Chair, I think we can call items 7 and 8 collectively together.
Okay.
Items 7 and 8 are filings from Freedom Energy Logistics, LLC. Item 7 being an application for a license to supply natural gas and natural gas supply services in Maryland. Item 8, an application for a license to supply electricity or electric generation services in Maryland.
Good morning again, Mr. Chairman, Commissioners. Kenneth Albert on behalf of staff. These two items address requests by Freedom Logistics, LLC, for authorization to operate as an electricity and natural gas broker for commercial and industrial customers in Maryland. Their management team has significant experience in the energy industry. We did look at 3 events in their history that we had some concerns about. In February 2013, the New England Regional Grid Operator, the ISO, suspended the authority of their Freedom's affiliate, PNE Energy Supply, to operate as a supplier in the ISO wholesale electricity market. The suspension was caused by their violation of the financial integrity standards, and this in turn was triggered by a spike in wholesale prices. And we've seen this with suppliers. When there's a spike in prices, it sometimes causes the suppliers to violate the collateral requirements. And as a result of this, they had to transfer customers, and because of the timing issues, they made an unauthorized transfer of customers to default service by the local utility. This unauthorized transfer was addressed by the New Hampshire Public Utilities Commission. PNE notified the PUC that the transfer was to a different supplier. However, because of the need to quickly do the transfer, they had to resort to the default service by the utility instead of directing the customers back to a different supplier. As a result, the enforcement proceeding noted this and also pointed out that another issue was failure to notify the Commission when the company expanded its service to CNI customers. They originally were only serving residential customers. The company has since, a month after the default was noted in February 2013, they did cure the default, and they reached a settlement with the Commission in New Hampshire on these violations. Staff is always concerned when there's a default by a supplier in a RTO market or where there's an enforcement proceeding in another state that involves an entity that's seeking Commission authorization. However, the enforcement proceeding and the default did not involve improper marketing practices and were readily resolved and did not result in harm to customers. As a result, when we also looked at their performance in other states, and that too was satisfactory, as a result of all of these factors, we recommend that the Commission grant the request for authorization by Freedom to operate as a broker for commercial and industrial customers. And I would note representatives from Freedom are here at the other microphone.
All right, thank you. Questions first for staff? Okay, if not, we have representatives from the company here. Anything you would like to say or add?
Thank you for staff's cooperation. This is Christian Stevens on behalf of Eckert Siemens, Charon and Malat. With me is the COO of Freedom Logistics. And thank you again for the consideration and recommendation.
Thank you. Any questions for the company?
I would,
Yes, first Commissioner Linton, then Commissioner O'Donnell.
Thank you, Mr. Chairman. Good morning. Could you tell me a little about what Freedom has done since the matter in New England to improve your company's interaction with the regulatory body there?
Certainly. Thank you for the question, Commissioner. The other entity involved was P&E, which was our supply arm that we've been operating at the time. As a result of what happened during the polar vortex in 2013, we had a number of customers that were commercial customers on a real-time pass-through product, which required significant increases in our collateralization requirements at the ISO in New England. Unfortunately, because of the fact that prices ran up at a factor of 6 or 7 times their typical values, we were unable to continue to collateralize the amount of customers we had in the marketplace at that point in time, which caused, unfortunately, the shutdown of our load asset account with New England ISO. As a result, we've actually significantly pared down our supply arm of the company in P&E, so we're only serving a few hundred customers, I believe, at this time. When this occurred, it was a few thousand. I think it was about 8,000 customers we were serving at the time. So now we've moved really to focus on the broker market or the risk-off transactions, where we're acting as a middleman in these agreements and not taking title to the power and then passing it on to the customer.
Okay, so one of the actions that happened back then was that, and the Commission staff noted that there was some concern about P&E serving non-residential customers when they had the authorization to only serve. You were serving both when you're only authorized to serve one, residential.
That's correct, Commissioner.
So since that time, has there been any, what changes has the company made internally to make sure that type of issue with communication between the Commission and the company won't occur again?
Back during that time, I would note that we were startup getting involved in the energy markets. We were not using counsel like we are today in terms of making sure they're going through applications, making sure everything is correct. That was an unfortunate accident on the application process. I would note, as you've probably seen down here in Maryland, the threshold for service of residential customers is typically higher than it is for commercial customers. So it was an unfortunate mistake on our end, but again, we've retained the services of Eckert Siemens and other law firms to help us with our application process throughout the other jurisdictions and to make sure that that issue doesn't arise again in the state of New Hampshire.
So for purposes of your engagement in Maryland, then, are you also going to have Maryland presence in addition to counsel?
I'm sorry?
Are you going to have a presence in Maryland with the addition of counsel?
A presence in Maryland, how? In terms of serving clients, we would hope to, with your approval, of course. But in terms of a physical location?
A physical location, representatives of the company?
No. Typically, right now we're expanding our licenses in some of these other jurisdictions outside of New England because we have some national clients that have presence in states that are outside of New England doing the territory. So we're not actively going to be, at least at this time, pursuing new customers that aren't affiliated with current customers that we have.
Okay. Thank you.
Sir, can I ask you to state your name and title again?
I'm sorry. Bart Frometh, for the record, Chief Operating Officer of Freedom Logistics, LLC.
Thank you.
Mr. Chairman, I just wanted to note for the record that the buck sheet for item 7, page 5, second full paragraph, second sentence says, as Freedom is seeking to operate as a broker in Maryland, will not take title to electricity. That particular buck sheet should say gas. The one for electricity says the same thing, but the commodity should be gas, just for clarification for the record.
Where is this now?
Right, anything else for the company? All right, gentlemen, I want to thank you for being here today and answering our questions.
Thank you.
That do we have a motion for items 7 and 8?
Yes, Mr. Chairman. For item number 7 and 8, I move we grant the company a license to operate as a natural gas supplier and as an electricity supplier in Maryland, limited to broker services for the customer classes and service territories applied for and recommended by staff, and direct the company to file notice with the Commission within 30 days of any changes to the information in the application.
Is there a second?
Second.
All those in favor signify by saying aye.
Aye.
Motion carries.
Mr. Chairman, I think we can take 9 and 10 together as well.
Okay.
Items 9 and 10 are filings from Litz Ventures LLC. Item 9 being an application for a license to supply electricity or electric generation services, and item 10 being an application for a license to supply natural gas or natural gas supply services in Maryland.
Good morning again, Mr. Chairman, Commissioners. These two items address a request by Blitz for authorization to operate as an electricity and natural gas broker for commercial and industrial customers. Blitz has significant experience in the energy industry, and their performance in other states has been satisfactory. Therefore, staff recommends that the Commission authorize Blitz to operate as a broker for commercial and industrial customers for both natural gas and electricity.
All right, thank you. Any questions for our staff? Not, do we have a motion?
Yes, Mr. Chairman. I move that we grant the company a license to operate as an electricity supplier in Maryland, limited to broker services for the customer classes and service territories applied for and recommended by staff. Direct the company to provide marketing and training materials specific to its Maryland operations to the Commission staff 30 days prior to utilization of the materials in Maryland. And direct the company to file notice with the Commission within 30 days of any changes to the information in the application.
Are you going to make a recommendation for item 10 as well?
Sure. What I just said, forget. Item 10 as well.
Very good, abbreviated motion there. All right, do we have a second for items 9 and 10?
Second.
All those in favor signify by saying aye.
Aye.
Motion carries.
I need to ask staff, do you want to take items 11 and 12 collectively together or separately?
Yes.
Okay. Mr. Chairman, items 11 and 12 are filings from Sandpiper Energy and Chesapeake Utilities. They're both revised tariff pages. The company's proposed to modify its tariff languages with regard to its annual rate class review process.
Good morning, Mr. Chairman, Commissioners. Annette Garofalo on behalf of Commission staff. Chesapeake Utilities Corporation and Sandpiper Energy, Inc. are affiliated companies. Each company reviews usage of customers, by customers rather, annually to make sure they are in the appropriate class. Currently, both companies use the 12 months ended in August for reslotting. However, the budgeting process uses a 12-month period ending in May. This requires an estimation for the months May through August. The tariff amendments proposed would change the usage review to a 12-month period ending in May in order to end the need for estimation. Staff recommends the Commission accept for filing the revised tariff pages for both companies effective May 1 and direct Chesapeake and Sandpiper to file clean copies of the revised tariff.
Thank you. Any questions for staff? Not, do we have a motion for items 11 and 12?
Yes, Mr. Chairman, with respect to items 11 and 12, I move we accept the tariff revisions for filing and direct the company to file clean copies of the affected tariff pages with an effective date of May 1st, 2018.
Is there a second?
Second.
All those in favor signify by saying aye.
Aye.
Motion carries.
Mr. Chairman, I think we'll call items 13 and 14 collectively together as well. Items 13 and 14 are filings from the Baltimore Gas and Electric Company, item 13 being its report on its prepaid pilot associated with case number 9453. And item 14 is also a filing from Baltimore Gas and Electric Company. It's proposed tariff pages associated with its prepaid pilot.
Yes, by application filed April 21, 2017, BGE sought authorization to conduct a prepaid pilot program whereby customers, if selected to participate in the pilot, would agree to pay for energy service in advance of use through communication with the company keep their accounts open through prepayments to BGE. Discontinued prepayment would avoid service termination, which the company terms a voluntary disconnect. As part of this filing, BGE sought waivers of COMAR sections that would otherwise apply. By Order 88438, issued October 25, 2017, the Commission rejected BGE's prepaid pilot tariff as filed, and among other things, directed BGE to report within 90 days on 3 issues which are discussed in staff's comments. Although the Commission rejected the pilot as filed, it approved the pilot subject to certain modifications, and a new tariff was filed in addition to the report the Commission ordered. The modifications are set forth in these comments which staff proposes, and by letter order dated March 12, 2018, the Commission suspended the revised pilot tariffs for 60 days and asked for comments no later than April 18, 2018. Staff recommends the Commission, first with regard to the report, staff recommends the Commission note the report. The working group continues to meet, and staff expects to file a final work group report for the Commission's consideration at the end of the work group process. Staff recommends the Commission suspend the prepaid pilot tariff for an additional 60 days in order that BGE may review the tariff to include all items addressed by the Commission in its Order 88438. This includes the 8 items noted by staff in comments as not included in BGE's revised tariff. In addition, staff recommends that the 3 items on page 5 labeled ABC also be included because these are essential to the program and would be in a typical tariff. Finally, staff would like to note that the terms and conditions of the pilot are not truly final, and it is possible that further revisions to the pilot tariff would be required. With regard to the tariff currently before you, staff recommends BGE be directed to refile the proposed tariff to incorporate the order requirements not included in the tariff as listed in staff's comments, together with any rules that customers would be subject to under these terms and conditions. In addition, as of I believe it's Monday, although I just found out about it last night, BGE has filed an additional tariff. It would become effective on 2 days' notice. Staff opposes the effective date, but we also we have not truly reviewed that tariff. We do think that BGE was trying to respond to staff's comments in a positive way, and we do appreciate that. But again, I'd like to stress that the actual terms and conditions of the pilot program are not final, and we think that, well, it is possible that additional issues would come up in the work group, and we would like to have in the tariff the items that you directed be in your order, as opposed to have the order available online, which is what BGE has proposed.
Okay, thank you, Ms. Garofalo. We'll start with questions for staff. We also want to hear from OPC and, of course, the company. Commissioner O'Donnell.
Just, can you clarify that new tariff that was filed with potential for 2 days' notice on the effective date? Make sure I understand what you're telling us.
It's dated. The letter is dated October 23rd. It responds to all the comments that were set here, that were filed in response to the Executive Secretary's proposal. I said May, apparently April 23rd. And it has an effective date of April 25th.
So it was filed on Monday with an effective date for today?
Correct.
And what's the status of that filing? Is it before us?
It was, it's linked
Got
to
it.
the current filing.
I got
So
it.
I guess you could say it's before you.
Okay, so that packet was added to the commissioner's packet on this matter yesterday.
I believe so.
Okay, I'm just clarifying, make sure I understand the nature of some of these so that we can digest them. All right, thank you. I got a second question for staff on the buck sheet. On page 2, the last paragraph says, by order 88-438 issued October 25th, 2017, the commission rejected the pilot tariff and filed, but approved the pilot subject to certain modifications and directed BG&E to report back in 90 days on specified items. And then it says this, the COMAR waivers were granted. What COMAR waivers are you referring to? Because my memory says we granted certain COMAR waivers and we held others in abeyance because of some concerns that we had. I think.
I suspect you're correct. So I read it. We did object to some of them. We thought they should come before you individually, and I took them as being completely granted. But
Okay. I mean, it's just.
I don't think I brought the order with me.
All right.
I've been busy handwriting my comments for the last couple days.
I get it. All right. Well, I just.
But we actually do have the order.
Okay.
So, So I think you're referring to the fact that you were concerned about the consumer protection issues for terminations.
Exactly. Absolutely.
And so staff is as well.
Okay. So we haven't granted all the waivers that were requested in the original filing, and this statement just says
That
the
should
COMAR
have
waivers
been-
were granted. And
That should have been a more refined statement.
all right. Thank you. I just wanted to clarify that for the record. Thank you.
Okay, anything else for, yes, Commissioner?
Yeah, if I could just ask, I'm interested to know I guess, the status of the work group. I mean, from what I'm reading here, it sounds like there were concerns staff had, MEA had, and WGL brought up something, and then there's a response from BG. I mean, have these conversations actually taken place, or are these just being thrown out there and
I'm going to
no
let
one's
Mr.
really talking to each other? Are they just?
Yeah. I'm going to let Mr. Baker respond, but I will say that the status of the work group, it's always possible it's in the eye of the beholder. So.
Okay, good. I was just concerned. I mean, it seems like there were some points made, and then they just seem to be just dismissed by BG without any kind of more understanding of granularity of what's happening at the work group level.
Mr. Chairman, Commissioners, Benjamin Baker on behalf of staff. The working group has met 5 times since the order has come out. As of now, we are in the beginning stages of reviewing most of the communications material that BGE will be putting out there. And as part of the working group also, we have been reviewing aspects of the pilot that BG has been putting in front of us. And also as different parties have put concerns on the table. Some of those that have been put forth by the parties today we have been working through and continue to work through. And some of them might be new or related to the report as it has just been filed. And as noted in one of the data requests, the working group is still continuing, and as we stated in our report, the working group is still continuing to meet, and some of this will continue to evolve as we go. So until the terms and conditions are really finalized, I would argue the rules are not complete on the project. And so it's hard to say that the pilot is ready to go.
Okay. Okay, so that's really the staff that there are still active issues that are being discussed right now. There is no resolution, and so it's rather premature for us to be locking anything into place at this point. Is that basically what staff is saying?
Yeah, so staff would think that there are still issues on the table that are being resolved today. BG might not agree, but we believe there still could be potential issues that are not yet resolved.
Okay, but the other parties agree that
As you
all
can
these
see-
issues
as you
have
can
not
see
been
in the
resolved
other
yet. So only
comments
one
from-
party agrees that they have been resolved, and everyone else doesn't agree.
Right. But
Okay,
I'm not,
thank
but
you.
I'll let BG speak to if they believe it's...
All right, appreciate that
Thank you.
insights. Thank you.
Okay.
One more question.
Well, first, if you don't mind, we'll go to Commissioner Herman, then Commissioner Tom.
So I note in your comments that you're suggesting that a lot more detail be added into the tariff. And is the reason for adding that detail because you're concerned that you wouldn't want terms and conditions to change without notice? For what reason do you want that level of detail in the tariff?
I'm going to also ask Mr. Baker to chime in, but I would say that as a legal matter, if this were not an unusual program like the prepaid, there would be quite a bit of detail in the tariff. To the extent that there's a choice between more detail or less detail than a typical tariff, we think something like the prepaid program should have err on the side of more detail because it's completely different than anything the customers have experienced or the BGE, I believe, has administered in the past. And we would want to avoid any confusion. I know that BGE in their new tariff offers to put the Commission's order online. We're not sure that that's as useful, although it may be that putting the terms and conditions on a website when those are finalized would be appropriate.
Mm-hmm. So I guess these provisions, it's not because you're concerned that they might change and, without notice. What you're more concerned about is just making sure everything is out there as much as possible. Would I have that right?
Correct.
Okay.
We don't think...
Benjamin Baker again on behalf of staff. So the main concerns are, one, customer accessibility to the information, as has already been stated. And it's not just customers, but also, I guess, helpline representatives. So if the Commission receives a customer complaint, one of the first things you're going to go to and refer to is the tariff. If that information is not available in the tariff, that requires then digging in orders, and now we're kind of off to the races as to where it is available now. The terms and conditions being available online, that could also suffice as long as it's made aware of in the tariff. Other concerns, yes, we did raise the concern that possibly the terms and conditions could be changed without Commission review. Now, granted, we are going through the working group process today, and during that is a place where they are partially being reviewed, but I guess it comes down to, do we believe that the terms and conditions are communications material? Are they set rules that the customers are beholden to? And so if they are rules, and that seems to be customer protection then, or at least rules related to customer protection, those should we would consider being things that we make more explicitly stated in a tariff, so when customer complaints come either to us or to the company, they're readily available inside of a tariff. That was one of our main concerns with the tariff being as bare-boned as it was today. That wasn't trying to say all the terms and conditions should be included. It was more thinking about what rules should be included, because we didn't go through the order and list out every single part of the order as should be included, but it was mostly those that were customer-centric, customer protections that the Commission had put forth in their order. That's what we had put and asked to be included inside the tariff. But in addition to those Commission orders, we said there's other rules that are being applied. The customer will be enforced, will be required to partake in if when the terms and conditions are signed. And those rules, we were saying those should probably also be included in the tariff. But that was our interpretation of what we thought should go inside of a tariff, especially if we refer to my footnote on page 4 of the tariff buck sheet. Mm-hmm. There's a COMAR regulation 20.50.03.03 that does state that a utility's rules or terms and conditions describing the utility's policies and practices in rendering service. And it does go on to list other things inside that COMAR regulation that should be included in a tariff, but using that statement in the idea that rules should be applied to the tariff that we would include inside, the tariff, the rules that would be inside the terms and conditions.
Right, and for my part, I think that one of the things to me that's important is making sure that including it in the tariff may be appropriate, but also in the communications, because a lot of times customers won't go back to the tariff. They're going to look at the materials they receive. So duplication in this particular instance, I think, is not a bad thing.
Right, and that's kind of our, like, we weren't saying don't have the terms and conditions. It was almost mirror the rules inside the terms and conditions, not the full terms and conditions, but the rules from the terms and conditions inside the tariff as well.
Okay.
That was all.
Thank you very much.
Thank you.
Thank you, Mr. Chairman. I appreciate the staff's diligence on this because these are very important matters. And when I opened my Facebook account, I think I clicked I agree on terms and conditions. Now they know more about me than I know about myself, so they're very important. I wanted to ask you about the recommendation on item 14. The recommendation is to suspend the tariff an additional 60 days in the buck sheet. We have a date in our proposed recommendation here, but what date does staff envision that should be?
Well, there are some complications here. So we selected 60 days, which is, I believe, August 2nd. No, that's not right. We selected 60 days, an additional 60 days, in order to give BGE time to comply with what we had requested. However, we are concerned about the finality of the terms and conditions, which we think should be at a minimum accessible through the tariff, perhaps through a link that's in the tariff that would go to the terms and conditions on their website. And so the reason one for the asking for an additional 60 days is to allow BGE to comply. But reason two is to give BGE and the working group some finality about what's going to be, how's this program going to work. And so we really wanted the tariff not to be final until we're close to that. It's my understanding that while we thought initially this program might go into effect in September, that now it may be December-ish.
So I appreciate that. I'm just trying to make clear in my mind 60 days from when. I think we should take the appropriate time to get this right. It's very important. But I'm trying to get the clock right in my mind in terms of when this is going to
So a problem is that you can only suspend a tariff for 150 days, and this one's already been suspended for 60 days, so we were going for 120.
Okay. And if we had to suspend further, then we could bring the item back if we're still not done.
Yeah, I think you could just issue an order.
Okay, very good. So it's 60 days. So the motion that's been proposed to me, and I'm going to be making this motion, I think, is suspend the tariff an additional 60 days or until August 7th, 2018. I'm trying to figure out, does the 60 days comport with the August 7th date? And it's not clear to me that it does. So help me out.
I haven't done that counting, but I think it's intended to be 120 days from the effective date of this tariff, not the one filed Monday, from June 9th. So that's my understanding.
So 60 days from June 9th.
No, 60. No,
Why don't
60.
let me ask our executive secretary to shed some light.
I may be able to elaborate a little bit on this.
Yeah.
So the commission
Thank you.
issued a notice requesting comments, and in that notice, after the company filed its report and its tariff, it requested the comments, and then it also suspended the tariff revisions that BGE had initially filed, which was a proposed effective date of April 9th. So we suspended it 60 days from April 9th. Here we are back on the agenda again, so an additional 60 days would be 120 days from April 9th. What's, I think, confusing is that BGE came in today, as Commissioner O'Donnell noted, and on filing its response to parties' comments, including staff's, they also attached revised tariff pages, which, on essentially 2 days' notice, put in a new effective date of April 25th, which is today. So I think that's what's causing the confusion.
All right, I got it now. So this is an additional 60 days on top of the original extension of the tariffs of 60 days, which takes us to August 7th, and now the math makes sense to me. I appreciate that. Thank you.
Yep.
Thank you. Thank you, Mr. Chairman.
Great. Just ask one question on that. Just following up, I strongly agree with Commissioner O'Donnell that it's important we get this right. Would there be one option be just to reject the tariff without prejudice, and then direct that the work group go back and try to reach consensus, or direct that they reach consensus before they come back with the tariff? Is that an option as well?
You could do that.
Say that again?
Can we just reject without prejudice with the direction that the work group continue? I feel like in our order we gave, I thought, some very concrete direction.
Right, and maybe we're getting a little bit ahead of ourselves, but yeah,
Okay.
we still have to probably suspend the tariff.
Or reject without prejudice.
We could also
no,
do that, Mr. Chairman, if I might suggest, when it comes back up, comes before us again, we still have the opportunity to reject it at that point.
Okay.
So,
yeah.
Not that we would, but we have that
Yeah.
option.
Okay, yeah, all right. Just wanted to understand what all our options were.
All right. Yep.
Just perhaps a really tiny detail, to the extent that the tariff that was filed yesterday is a live tariff filing, you actually might want to reject that one because it has an effective date of, if not today, at least 28 days from today. So
All right, will Mr. Executive Secretary make sure we address that when we get to our measure. Okay, let's hear next from Ms. Curry, then we'll hear from Mr. Alson.
Good morning, Chairman, Commissioners. Kim Curry, representing Baltimore Gas and Electric Company. I want to cover a few things. Commissioner O'Donnell and Commissioner Richard, you had asked kind of about the status of the working group. I have the October order in front of me. This is the order that you issued approving the prepaid program. And the exact wording is, it allows us to move forward with it. Let me just find that wording really quickly here. After review of the written and oral comments, the Commission grants BGE's request for authorization to move forward with the prepaid pilot subject to the conditions herein. You rejected the tariff, but in this language, you authorized us to go forward with the pilot itself. So the tariff is what is before you today. Commissioner O'Donnell, you had asked about the different waivers, and there might be some waivers out there that are unresolved. There were 3 categories of waivers that BGE requested. There was a Category A that spoke of billing-related waivers. There was a Category B that talked about supplier waivers. And then there was a Category C that listed various COMAR waivers. You expressly adopted or waived Categories A and B, and that's also in the October order. Page 15. We grant BGE's requested waivers in Categories A and B. With regard to Category C, on page 17, you state, with these protections in place, we grant the remaining waivers for the requirements listed in Category C. On pages 16 and 17, you list a number of different conditions that you wanted to see. Just as an example, we should ensure an immediate switch between prepaid and traditional postpay service anytime the customer requests. If the customer requests to switch to postpay during a 5-day extension period, we cannot add an additional deposit. So you listed maybe 6 items, and you said with those protections in place, you grant the remainder of Category C. We address these in our 90-day report. So if there's anything that you think is outstanding, please let BGE know. We think we've addressed all the issues that you've raised in the October 2017 order, but if there's anything outstanding, we are absolutely willing to hear what you think has not been accomplished yet. So we all understood that the tariff was really the last remaining item for the commission to consider. You've given us approval on the actual prepaid program itself. You've addressed the waivers. We've addressed the waivers in our 90-day report. So we think that the last thing that needs to be addressed is the tariff, and that's why we were here before you today. To address the specific comments that were filed, we filed a response on Monday. The comments were filed on Wednesday. We filed the comments on Monday responding to those. And Commissioner Richard, I don't know if I would describe our response as dismissive. In fact, I would say it's just the opposite. There were many times in our comments we specifically stated these are items we would welcome further dialogue in the working group on. So we weren't intending to, dismiss anybody's concerns. There were a number of them where we said we're willing to continue this dialogue, and we think it's been a very productive dialogue in the working group so far. There are some items where we do continue to disagree, and that's what we were stating in our comments, not to be dismissive, but we have the right to disagree with a party that raises an issue. And the main item of disagreement was suspending the tariff for 60 days. We don't think that that's necessary. We're ready to move forward with the pilot. Again, you've given us the authorization to move forward. We're ready right now to do that. We've talked with our IT people. We've identified the IT and system changes that are necessary to implement the pilot. But we are waiting for final approval on the tariff before we go forward and build those requirements. So we don't want to invest the time and resource and money to take that next step until we get final approval of our tariff, and that's what we're waiting on. And we don't think that 60 days is necessary to do that. And getting to the substance of staff's argument about the additional detail in the tariff, the purpose of us making that filing on Monday was not to complicate things. It was to attempt to offer an alternative to address staff's concerns of wanting to see this additional detail. A lot of the things that staff recommend to be included in the tariff we think is better suited for a customer-facing document versus a tariff. For example, one item would be we cannot credit report customers who are terminated as a result of prepaid. Well, that to me feels more like terms and conditions, something you put in an enrollment document versus in the tariff. And so what we tried to do in our alternative is in our tariff cross-reference the terms and conditions. Note that it's on bge.com, available to all, visible to all, and very transparent. And also in our tariff that we filed on Monday, cross-reference the order. So to the extent that staff didn't believe that that the order itself independently, binded us, we put a reference to the order saying that our program would be subject to the order. So again, not to complicate things, we did it really to try and offer an alternative for the commission to consider.
Ms. Curry, let me ask you a question. So the April 23rd letter we received with an amended tariff, what is BG&E's intention? Is this an amendment to the proposed tariff before us, or is this a completely separate tariff we have to handle?
It's an amendment to the March 8th filing. So we had made our March 8th filing because you had rejected our tariff when we filed on March 8th, a refiled tariff in accordance with the October order. But after seeing staff's comments, we said, all right, we think that here's something that we think can address staff's concerns. So we're trying to be, kind of helpful in that regard, and then just put those description of what I had just mentioned, cross-referencing the terms and conditions and the commission's order on top of the changes we had previously proposed in the March 8th order. So it was, I think, two sentences or so, and that we added to the March 8th filing.
Okay, in terms of the 60-day suspension, I understand your point that you don't want to have to come back on April the 5th and get this tariff finalized, but that's just the outer limits of the suspension, and there's no reason that if an agreement can be worked out, that the commission couldn't take this up in 30 days or 45 days.
We could certainly file earlier if you're inclined to suspend the tariff and direct us to do what staff has asked us to include. We could come back to you very, very quickly with a revised tariff. If that if you feel that that level of detail is needed in the tariff, we can accommodate that, but we would not wish to wait 60 days. We could file something, turn that around very, very quickly.
Okay, I got a question.
Questions? Yep, for Ms. Curry. We'll start with Commissioner.
So, Ms. Curry, the company says they addressed the concerns we had with regard to the consumer protections in Comar, and that's really why we sent this whole issue back to the work, one of the reasons we sent this whole issue back to the work group, and with a report required in 90 days. Do you propose, you say you've answered all of those concerns, do you propose to put all of those answers in your terms and agreements?
In the terms and conditions, I believe there are, let me just take a quick look at them here. Some are already in the tariff, but yes, we intend to put these in our terms and conditions.
Are they in the tariff, all of them?
No, not
Okay.
all of them.
So that's the crux of one of the points of dispute, right? You don't want to put
Yes.
them, okay.
That's some of the things we don't know.
Once
necessarily.
they're out of the tariff and into the terms and conditions, then you can change those terms and conditions outside of our purview.
We could update them if something changes.
Sure. So we lose see, those consumer protections are very important to the commission. That's why we specifically sent it back to the company and the work group to work on, not to make it malleable in the future.
No, now let me be clear. We would not change anything you've given us clear direction to do and include. That would not be our intent. The order binds us to do that. So if you're saying a customer gets a 5-day extension, we can't just change it to 3 in our terms and conditions because we're still bound by this order. So we would still remain bound by the order. I was referring to, I don't know if there's something that's outside of the order, circumstances come up in the pilot that we think makes sense to update our terms and conditions on. But these consumer protections that you've already laid out, we would not change that.
Why did the company think it would be helpful to this commission to file a tariff revision proposal on a Monday with an effective date on a Wednesday? Why did the company, knowing how this commission operates, why did the company think that that was being helpful?
Yes, I'd love to answer that.
Good.
It is because we were addressing an argument that was raised by staff. To the extent you agreed with or did not agree with staff, or maybe you were in the middle between staff and BGE, this was to give you an additional option today to consider.
Well, to be honest, I haven't read it because I got it yesterday afternoon at about 5 o'clock as I was preparing to drive home. So it's not helpful, in my opinion, to this commission, regardless of your interactions with staff, because we're making the decision here, and the company knows very well the challenges were proposed with digesting this stuff. And to be honest with you, I haven't read the report because I got the report yesterday at about 5 p.m. at the same time. Now, the staff has read it, but I have not, and I'm going to take the time to digest it and read it.
Absolutely. And I will just say that the comments were filed on Wednesday. Staff comments were filed on Wednesday. The Commission's website says for items on the administrative meeting, they're filed on that Monday. And so we got it in a little late on Monday. Your system was down. The Commission's system was down, so we had to hand bring it over. We couldn't file it electronically. And the report that you said that you had just got, we filed in January.
I know that, January 18th. I'm aware of that.
Okay.
But I have not read it yet because I just got it presented to me yesterday afternoon personally. It's not your problem, but I'm telling you, this commission is going to take the time, and I'm not humored at all by a tariff filing on a Monday with an effective date on a Wednesday.
Again, it was not intended to be to make things complex. We really thought we were helping the situation. I see now that it was not, but that was really not our intent to make things complicated. We really did want to offer you an additional option to consider.
Okay, Commissioner Richard.
Yeah, again, I think Commissioner O'Donnell has expressed very well the same, I guess, frustrations, concerns that I have. But I'll be honest, I had some real reservations about whether or not we should be, regulated utilities should be offering prepaid service to begin with. But, you know, Optum said that I think these are important services, an important option that Marylanders, all Marylanders should have. But again, I think there are very, very important issues with customer protections. I think MEA brought up some very important issues related to, you know, ensuring we do not harm our retail choice in this state. And so these it's important that we not just, you know, here, you know, at the last minute, here are pending concerns. These are things that where staff may say are not compliant in the program or have not been addressed, and then be told we got to do this today. So I hope that everyone will go back, and that when we get another filing, it won't be just, you know, back and forth letters, but we will, you know, MEA will make a recommendation, and you know, it won't be just for the company, we disagree with it, and then I'm kind of left wondering, well, gee, now, you know, I wonder if MEA is okay with them just disagreeing, or, you know, if staff have raised issues, or OPC have raised issues about customer protections, you know, whether they truly have been addressed. So I'd like to see progress being made on this, but I really think that this was a bad way of continuing the process, and I, for one, would really like to know that important state agencies like OPC and MEA and our staff are engaged, and that there is some consensus at the end of the day. So not really a question, but again, I do hope that you know, we will see progress, and then when we face this again, it'll be maybe a little more pleasant of an experience for all of us.
Just to, again, reiterate, you have set guidelines in the October order. Those exist today. So if you're concerned that we're going to somehow change it, that's not going to happen. You've given us guidance in the October order. You've given us guidance as to what consumer protections you'd like to see. You've waived certain ones, and you've asked us to incorporate certain ones. We have advised you of that in the January report. So I don't want the takeaway to be that BGE wants to go and change, you know, consumer protections to our liking or disliking. No, we are going to adhere to the October 2017 order. So I do want to really make sure that that gets across. I don't want the impression to be that we're somehow, by approving a tariff today, going to just kind of change what the Commission has already ordered us to do.
Commissioner Linton, and then Commissioner Herman.
Yes, thank you, Mr. Chairman. Ms. Curry, thanks for being here today. Would you would you acknowledge that if the Commission were to adopt this tariff, that in the event there's other matters that the work group determines needs to be addressed or raised in the tariff, that there's the Commission can still make those changes to add additional protections if they come up later or we realize they need to be done?
I think the answer has to be yes to that question. The reason why I am just hesitating a little bit is that we are going in the process of building the requirements of the program. And so one of the things that we didn't want to do is invest IT resources, costs to developing this program and system changes, and then 3 months down the road have something change that would change what we've already invested in, because that's not a good use, an efficient use of money. So we really did want finality before as it relates to the tariff, before we started building those IT changes, because when that happens, you are looking at increasing costs. So we really want to be efficient with our costs, but you know, to the extent there's something major you find, of course we would have to find a way, or an additional change that you want to see in the pilot. We would, of course, have to find a way to make that happen. Just recognize that that could affect the cost of the program that we initially communicated to you. So I guess the answer to your question really is yes, but it would involve, you know, additional resources and possible additional costs.
Okay. The kind of type of topic or issue I'm thinking about is, just as an example, is one that the Commission staff raised regarding the assessment of a fee, application fee for a customer that would like to participate in the program. and it was my first week on the bench, but I don't recall that being one of the items that we talked about back when the first proposals were made.
Yeah.
Was that one of the topics that we discussed back then?
I cannot recall, but I will say that this is a fee that's charged to all customers today that initiate a new service. It's called a service application fee. It's in our tariff. And so since it hasn't been specifically waived for prepaid customers, we feel like we have to charge that. Staff characterize it as a reconnection fee, and that's not what it is. It is an application fee for someone who calls BGE up to initiate a new service application. So hasn't been specifically waived, so it is something that we were going to charge all customers, including prepaid customers.
So as part of our deliberations and discussions from the time of the original filing and all the work group meetings, et cetera, till now, clearly there are some parties that have some reservations still about the status of where we are now, the type, what should be in the tariff, what shouldn't be. For a suggestion like this one, clearly it's in the tariff already, you currently charge it. The $40 fee, what happens to it for a prepaid versus a postpaid customer, the Commission hasn't really thought through in a sense that it hasn't been presented prior to, at least, again, to my own memory till now. Would you at least acknowledge that these are some of the types of things that some of the parties are concerned about, and perhaps the reason for some of the reservations that some parties have regarding moving forward?
It's a $20 or $25 fee, I believe. My response to that would be, we as a working group have been meeting since late last year, since after the October order. And the concern we would have, getting back to the request of finality, if the working group keeps finding things, the pilot will never get off the ground. So we do need, again, getting back to kind of my theme of, we need the certainty before we move forward, because it ends up delaying it. So if we have another 6-month working group, we're delaying it by 6 months again. So we really do want that certainty. And we do think that there are items that can continue to be discussed in the working group. If somebody, if we want to waive the $25 application fee, then we would probably have to update our tariff to allow for that. But I don't know if that's something that would stop us today from getting an approval on our tariff. And I'm mentioning this to say that we still want to have that dialogue with the working group as we go forward. But can we find a way to approve the tariff but still have the continuing dialogue to address concerns as they come about? But we think the October order already gives us the framework. You've already approved the program and allowed us to move forward. You've given us the framework of the things you want to see. It sounds almost now like it's the parties that seem to be able to tell us to add to what you've already told us to do. And I don't know if that's the proper way to proceed at this point. You've given us the framework. Let us go with that framework that you've already provided to us, and we could still continue and talk with the working group and bring items of non-consensus back to you.
Well, now, I certainly think that there are some concerns, not just among the parties, but even from what I've heard this morning, even from among the commissioners regarding the eventual initiation of the pilot. I mean, clearly this is a unique concept in Maryland, one that we're all interested to see how it turns out, what the end result would be. But at the same time, we want to make sure that we don't find something along the way that creates a challenge for us a year or two from now. And I think that's what the parties are, as they dig deeper into this, and look a little closer at some of the different issues, such as the application charge, which is something we really hadn't talked about before. But it's according to the tariff, it's a $40 fee, and so it raises a number of questions about what happens with the fee. Is it prohibitive for some customers? Is it coming out of assistance plans, et cetera? So I think that's what the concern is that's being raised. And just the concern of what's on the next page of the tariff, is there something else that we need to take a look at as well? And so I don't think we're going to catch them all, just because it's a pilot, so we're not going to be able to find everything to address every issue, and certainly you need finality both in the beginning of the pilot and at the end. And I think we've certainly identified that and made that clear along the way. So I don't know. I say you got a comment in your ear, so I'll let you make it.
I would say that this program would not function any differently than other programs. You always have the ability to come back in anything, any tariff, any service that we provide or file and you approve, you always have the right to come back and say, let's tweak it like this. So I don't think any of that will change. The hesitation we have is allowing, other parties, when we've been working in the working group for months, if they find something, is that going to hold up the tariff again? It's already been suspended once already, and staff is referring to another suspension. So that's the only concern. So what I was trying to offer is allowing our tariff to go forward, but to the extent there are things like that that come up after talking in the working group, to present that to you for consideration, we could still be able to do that, which would be no different than any program that we have before you today. The $40 that you're referring to, I believe, is the initial payment. So recall, in order to enter into the prepaid program, you have to put a minimum of $40 in your account. That's not really a service application fee. That's just a condition of the program, and we did mention that in our original filing. So that has been discussed. The service application fee is the $20. Again, I think staff had mischaracterized it as a reconnection fee. It's a service application fee that's charged to all customers. But the $40 I believe you're referring to was that initial payment, not a upfront fee or anything like that.
Okay. All right. Thank you very much. Thank you, Mr. Chairman.
So, Ms. Curry, I guess I understand that you're trying to address staff's current concerns in your most recent filing, but I would note that, as the chairman noted, there's nothing that would stop you from quickly getting back with the working group and trying to address those concerns and making a filing. I might ask you to consider whether just sort of taking staffs and then refiling within a week without talking to the working group might not be as helpful as having some discussions with the working group with some of the other issues that were raised. So I would just sort of encourage the company to think about that. But also, if you believe that you have the authority and you believe that you could subsequently address a change, that might come to the tariff, I guess I'm a little bit confused with the respect that you can't start programming because you believe you already have the authority to do the pilot. You're just waiting for the specific terms of the tariff. So, I think it's a little bit, like a chicken and egg thing, and I'm not sure that the level of these comments would necessarily stop you, but that's obviously the company's call to when to start implementing the IT changes. But I just think that I would urge the company to talk to some of these parties that have raised comments and try to do that as expeditiously as possible and come back because I do think that there has been guidance issued and discussion would be helpful.
Sure. Thank you, Commissioner. And the reason why we did hold up is because the order specifically rejected the tariff, and so there's a little hesitation, of course, in moving too far forward when the Commission has specifically rejected a component of your filing. So that was what factored into our decision to kind of hold off and wait until there was a final approval of the tariff. I just wanted to explain kind of our reasoning in doing that.
Thank you, Mr. Chairman. I want to engage you, Ms. Curry, in a little bit of discussion of our understanding of where this pilot status is, because the company thinks you have the authority to proceed with this pilot. I don't. I think you have an order that said you can start doing some work, but we need some further answers. Come back to us and report in 90 days so we can make a final decision on this. notion. So that's my view of the world. Yours is very different, I think. So we still have on the table the option to not approve any tariff in this matter. Would you agree?
You always have that authority,
Right.
yes.
So we could, the actions of the company, or if we change our mind up here collectively, we could effectively not have a pilot go forward based on the failure to meet the request for information adequately that we sent out in our previous order. Is that not so?
If you demonstrated that we did not comply, which you had said you haven't read the report yet, so
Right.
you can't make that conclusion just
No,
yet.
I'm going to take the time to read it. That's
But if you make that decision that we have not complied yet, then you could say we have not complied.
I just wanted to make clear that that option is still on the table, that this pilot, in my opinion, has not been greenlighted completely, as you kind of allude to, I think, that there is still the option to jeopardize this whole notion of going forward with a prepaid pilot program should the company not demonstrate to our satisfaction adequate consumer protections in accordance with the annotated code and COMAR.
And I was reading the exact words from your order when I was reading earlier, and so that's where I got the language from. And we did put in our 90-day report addressing the points that you raised in the order, and that's why initially I had said, to the extent you feel that we have not done that and not complied with it, please let us know what is still needed. I had mentioned that at the outset.
We indeed will.
Yes, if you feel like there's something that we did not do.
Thank
But
you.
again, I was just going off the words in the order.
I just hope you would cooperate with our staff and get us the answers that we'll need to have to finally approve this. But I will tell you that a tariff revision with a 2-day notice is inadequate on its face.
Okay, let's hear a quick question from
Just
Mr.
quickly,
Commissioner Richard, then I want to bring Mr. Khan up.
Yeah, and that, just quickly, that you keep referring to other parties. I mean, this is an important state policy we're looking at. So one of those other parties is the State Energy Office, and so that is a key input, at least for this commissioner, for me, to hear from. We're talking about waiving important customer protection. So it's vital to me that OPC, and I know where they stand, and the same with the staff. I mean, we rely on them for their expertise and everything. So they're not just other parties. They are partners here in making sure we get this right. So I just wanted to emphasize that when when you kept referring to other parties, it almost like they were kind of an annoyance to you right
No,
now. because
I think you're reading,
interfering with
a
your
little
moving
bit.
forward. So.
I don't know if that's a proper thing to read into what I was saying. All I was saying is that we have the right to disagree with those parties. They are partners with us, yes. They are participants in the working group, and we want to have a dialogue with them, as we mentioned in our comments. But at the end of the day, we still get that right, I think, to disagree with them. And we can have good disagreements and present those to you, and then you can decide. So that's the only point that I was making.
Mr. Khan. I see you're standing up, so please just introduce yourself and your title for our record.
I'm David Kahn. I'm the Energy Assistance Program Manager at BGE. Good morning.
Good morning.
Did you have particular questions?
Oh, no, you stood up, and I just wanted to give you an opportunity if you wanted to respond to a question. I wasn't sure why you were up. So before I moved on to OPC.
I appreciate that. I was hoping, if there's time and if you're inclined, that if there are any of the substantive issues that were raised by some of the parties that we could address very, very quickly for you today. I know that in staff's comments, in addition to the level of detail that they thought was appropriate to put into the tariff, they also had asked us to make a few wording changes to the tariff, including, help me here, Ben. We talked about the initial payment that a customer would need to make into the prepaid account. I think we had used it as a deposit, and I think staff preferred a different wording for that. And so that was one of the specific items that they asked for, and we agreed to that and changed it in the tariff, the new tariff or revision that we submitted on Monday. They also, their proposed wording was customers required to activate their account by depositing $40 into their prepayment accounts. Again, we thought that made sense, and we were fine with that. There was one other, I think, substantive change that they recommended, and that we also agreed, Yeah. So those were sort of the substantive recommendations that we saw from staff, in addition to the discussion we already had about the level of detail of program sort of rules and requirements that ought or ought not to be in the tariff. MEA, first of all, I want to commend them for their engagement in the working group over these past number of months. They were really helpful, and among their recommendations were that we be sure to make the final evaluation report from an outside evaluator publicly available and actually filed as part of our final report with the pilot. And we're happy to do that. They also asked that a lot of the data that comes out of the pilot be made publicly available, which again we're perfectly happy to do, and I think we put that in our comments. They had a few other questions that they wanted us to continue to discuss in the work group about the nature of competition and making sure that the pilot doesn't in any way hinder competition in the state. And again, we really welcome the input, and we're happy to continue talking with them about that. Any specific items that MEA has for us about how to ensure the competition is continued to be fostered, we'd love to continue that conversation. And so I feel that we did address MEA's concerns, specific concerns that they raised. WGL is another party that submitted comments. They want to talk with us further about ensuring that they know when their customers enroll in prepay. And we don't have a mechanism for that yet because they really just raised that issue with us last week in the filing on Wednesday. But I think they would say that we've been open and have continued to talk with them, and we will. We'll continue to. OPC had a number of recommendations and suggestions, some of which we've worked with and supported throughout the working group process, some of which we're sort of at loggerheads with them. I think there's a fundamental disagreement between BG and OPC about whether prepay should happen at all. And we certainly want to continue talking and working with them, but I think that at some point we may find that we just disagree on a few key items. And I hope that's not the case. I hope we can work these things out, but that's kind of where we are with some of these items.
All right, thank you,
I'll stop because there was no specific question.
No, I appreciate you going through some of the work you've done with the stakeholders, so that's helpful. Thank you. Mr. Auslander, you've been very patient. I'd like to welcome you. Good morning.
Thank you, Mr. Chairman and Commissioners. Jacob Auslander on behalf of the Maryland Office of People's Counsel. OPC supports staff's recommendation that more detail about the prepaid pilot terms and conditions be included in the tariff itself. We'd note that at this point, the substitute that BG has set out in its proposed tariff is not appropriate. The reference to Order 88438 says that it could be accessed on www.bge.com, meaning that unless the company is intending to replace its top-level domain with a PDF version of the Commission's order, that the participants would need to dig further to find what terms and conditions are going to apply to them. I'd also note that simply including these key pieces of information in both the terms and conditions and the tariff is not an insurmountable problem. And that because of the number of consumer protections that are going to be waived for these prepaid pilot participants, that there be an express substitute set of protections contained in the tariff itself. The comment by Mr. Khan that OPC did not support the idea of a prepaid program is true. But the comments that we submitted last week did not repeat that opposition. It sort of delved into the reality that this prepaid pilot is likely to move forward, and so in the interest of ensuring that some of the fears that we have are not realized, we made a specific recommendation that the company require, as a condition of eligibility, an open and active communication channel between the company and program participants, meaning that in addition to the alert that will occur when the customer initially enrolls in the program, that the company periodically confirm that that communication channel that was established at the outset of the enrollment is still active. And the reason for that is that all of the important information that would normally be provided to a customer of BG&E through mail or field collections is going to be replaced by text messages or emails or telephone calls that are going to occur electronically, and that are going to depend on the customer maintaining that email address or that telephone number to gain that information. Certainly, BG&E states that customers would be able to call the call center and obtain that information. But given the level of detail and the importance of maintaining this essential service, OPC believes that it should be a condition of eligibility to maintain that communication channel.
All right, thank you, Mr. Auslander. Any questions for the Office of People's Counsel? Not? Thank you very much.
Sure, thank you.
Ms. Garofalo, anything staff would like to add?
Just a single sentence in response to BGE's final bill generation. Staff really sees no reason to treat customers in the pilot the same as those who are on regular service, who've had 26 days to pay their bill, 14 days in which to receive and think about their notice of termination, perhaps another week or so. This is under the quickest of circumstances for the company to actually get out there and terminate them should they be a dual fuel customer. And so we do really strongly oppose their final bill generation charge and the filing of the bill. We also think it could actually affect what happens to the evaluation, because these customers may actually wind up leaving the program. It could create a smaller sample to look at the end of 12 months.
All right, thank you. Ms. Curry, I see you're up again.
Yes.
Is there anything briefly you wanted to?
I just wanted to clarify one thing that Ms. Garofalo said about the final bill generation. That applies when a customer is off service for 10 days or longer. We final the bill, and this is what we do with our standard pay customers. At some point, you do have to final a bill because you need to kind of close out that account and send those dollars to be collected through a collection agency, for example. So you can't just leave funds or charges out indefinitely. So for our standard pay customers, we leave a bill open after someone's terminated for 10 days, then we issue a final bill. And we were just proposing doing the same thing for prepaid customers, treating them the same way as we do for standard customers.
Great, thank you. Any final questions for
Just a comment, Mr. Chairman.
All right, why don't we do this now? I mean, I think we've heard from everyone. Appreciate everyone's discussion and answering our questions now. Items 13 and 14 are before us. I'll first recognize Commissioner O'Donnell.
First of all, Mr. Chairman, let me just say that I appreciate all the work that went into the report that we ordered back to us within 90 days from our previous order, and I think that's very important. Today is the first day that it's presented to this commission formally, although other parties have had it since January, mid-January. But today is the formal presentment to us. I believe our commission will take the time necessary, now that it's formally presented to us, to digest it and to consider it and to consider the comments that it has generated and to consider other concerns that it has generated and to take into account other thoughts that we have had after listening to the proceedings today. So I think that's very important to state, because if we note this report, which is what is recommended to us in terms of noting it, it doesn't connote approval in any stretch of the imagination, and I wanted to say that for the record. So for this commissioner, I'll speak for this commissioner, Mr. Chairman, but I hope others would agree. We have a lot to consider here, including the remarks of today's proceedings.
All right, thank you.
And I would agree with that, Commissioner O'Donnell.
Okay, so we have before us, item 13 is the report itself, which recommendation I think will be to note the report. Thank you for your remarks on the record, Commissioner O'Donnell, with regard to that report. I certainly am in agreement with that as well in terms of the issues still before us. And second is item 14, which is the proposed tariff that is for us. We also have the April 23rd letter, which is the amendment. I think how it was intended to the proposed tariff before us, although that amendment does say on it effective April 25th, 2018.
Is your microphone on? It's really hard to hear you then.
Sorry about that. Thank you, Mr. Auslander. I apologize for that. I turned it off briefly. So let me ask first so we have our ducks in a row. The executive secretary of this question. So the April 23rd letter with the which includes an amendment, an amended tariff. Are we on solid ground, including this in terms of any suspension of a tariff, that this would be included in that suspension? Or do we need to take this up separately?
I think, Mr. Chairman, that it was treated as an amendment, as Ms. Curry had stated. I think they were trying to get the tariff approved today. That's why they put a proposed effective date of April 25th on the tariff. If the commission elects to suspend further, I believe it would add the suspension on to the original suspension period from April 9th, depending if you elect to do that from those days, because that's what was presented to you originally.
Okay, that's easy. Appreciate that. All right, so let me offer my thoughts, and then I'll turn it over to others. So my thoughts are, certainly I think there are a lot of issues to work out, and I appreciate hearing everyone's positions. For me personally, I would have preferred that many of these issues had been worked out by the parties before they came to us, and if they needed more time, that this item be deferred and then brought back to us, because I think that it would be better, if in a stakeholder process we worked out some of these details. Some of these we may have to decide as a commission, if there can't be any agreement. But it's clear from the discussions that some of these issues I think can be agreed to in the stakeholder process. And so my view is we should suspend the tariff for an additional 60 days. I think, as Commissioner Herman noted, that doesn't mean it should require another 60 days to August the 7th for any proposed changes to be worked out and presented back to us. The sooner the better. And so I would encourage BGE to work with staff and the parties and file revised tariff pages as soon as practicable. And I think it sounds like that they are certainly willing to do that. At this point, I would not want to recommend as part of this motion that BGE must include in their tariff everything that staff has listed in their comments. I think that's a little premature as well. I still would prefer the stakeholders to kind of work that out. And it may be that they will all be included in the tariff, but I think if we're going to turn this back to the staff and to the parties, that be part of what they address. And so my thought is we should just for now, just suspend the tariff the additional 60 days. So with that, I'll turn it over to see if there are any additional comments.
I'm in complete agreement with what the chairman just said.
Great.
I agree.
Mr. Chairman, I agree with you, but I will say this. I don't think we should order the company to include in their tariff revisions that they're going to give to us everything in minute detail. But I will tell you that important consumer protections, of the three classes of waivers that we have granted, the consumer protections are the ones that most merit being spelled out in that tariff and not left to interpretation in somebody's terms and conditions. And I think that's very important to impress upon the company and other parties that those consumer protections were what jeopardized the most our approval of going forward in the first place because we wrestled with them, and they should not be treated lightly or casually, not that anybody will, but that they need to be given the appropriate consideration for inclusion, where appropriate, in the tariff.
Thank you, and I agree with you. I mean, I think that's why when the company said that, you know, if you want us to put this all in the tariff, we'll put it all in the tariff. I'm surprised that they didn't agree to that with staff and have that before us to approve. But so I certainly agree with those thoughts.
Thank you.
Okay, Commissioner.
Yeah.
All right, why don't Commissioner Dunn? Why don't I take this because I want to be on the safe side. I do want to address the April 23rd motion as well. So let me move to. I will move to suspend the tariff an additional 60 days until August 7th, 2018. Also with regard to the April 23rd filing with the amended tariff in that filing, just for clarity's sake, I will move to also suspend that until April the 7th, 2018, and
August.
I'm sorry, thank you, August the 7th, 2018, and to, as I stated, encourage BG&E to work with staff and the parties to file revised tariff pages as soon as practicable. Is there a second?
Second.
All those in favor signify by saying aye.
Aye.
Motion carries.
Mr. Chairman, do we need a further motion to note the filing of the report?
Yes, we do. Thank you. You want to make that motion? Yeah. That was item 14. Now we're back to item 13. Thank
Mr.
you.
Chairman, on item number 13, I move the commission note the January 23rd, 2018 report.
Very good. Let's see if we can scrounge up a second. Is there a second? All right. All those in favor signify by saying aye.
Aye.
Motion carries. Okay, we're going to take a 12-minute break. We'll be back at 12 o'clock, and we will pick up with items 15 and 18, the two stride filings.
Thank you.
welcome back everyone to the Maryland Public Service Commission's administrative meeting. On to our next item.
Good morning again, Mr. Chairman. and
Garofalo, let me introduce this first item.
Oh, yes, be my guest.
All right, the next item on the agenda is item number 15. It's Baltimore Gas Electric Company filed its supplement 444 to PS Maryland G9, its BGE Stride 2018 rate with its true-up and reconciliation.
Good morning, Mr. Chairman, Commissioners. Annette Garofalo on behalf of Commission staff. Section 4-210 of the Public Utilities article provides for accelerated gas company infrastructure improvements and the recovery of reasonable and prudent investment associated with those improvements through a surcharge. The Stride surcharge must be reconciled annually, and in order to base the reconciliation on actual numbers, a reconciliation filing is made no later than March 15th each year based on actual results for the 12-month period ended December 31 of the prior year, and representing the difference between actual collections and program costs. Baltimore Gas and Electric Company is in year 5 of its Stride plan, which was approved by order number 86147, issued January 29th, 2014. BGE's reconciliation was filed March 15th, 2018, and shows the impact of the Tax Cut and Jobs Act of 2017. It appears that BGE completed 59 projects in 2017. 16 projects showed a reportable variance. To the extent BGE encountered variances, staff believes they were explained and did not adversely affect the quality of the company's Stride work or result in a major economic harm to customers as compared with the proposed list filed in December of 2016. Staff does not recommend any disallowances at this time. BGE's Stride reconciliation resulted in an overcollection of $180,725 for residential customers and $12,834 for commercial customers, with an undercollection of approximately $60,000 for interruptible customers, for a net overcollection of $133,456. Staff has reviewed the calculation of these imbalances and believes the calculations to be correct and without material discrepancy. Ordinarily, the overcollection plus interest would be used to reduce the surcharge going forward. However, because BGE is over the cap for all firm customers, these customers would not realize a rate reduction in the Stride surcharge. BGE proposes that in cases such as these, the overage or imbalance above the cap be held in a regulatory liability where it will accrue interest at the company's authorized rate of return until the Stride surcharge is less than the maximum monthly charge and can be returned to customers. Staff believes this treatment is appropriate for overcollections in these circumstances. New surcharges thus remain at the cap and essentially unchanged. BGE has proposed new so for these reasons, staff recommends that the Commission direct the company to establish a regulatory liability in which the overcollection would be kept and earn interest at the company's rate of return until it can be returned to customers. In order to accomplish this, BGE has proposed new tariff language to accommodate the regulatory liability concept. Staff recommends the Commission accept the language for filing with an effective date of May 1, 2018, but direct the company to work with Commission staff to address its concerns regarding the company's current tariff language addressing the treatment of imbalances. Staff just wants to make sure that these two things are working in sync. And we think that these would be very short conversations. We just did not have time to accomplish them before today's meeting.
All right, thank you, Ms. Garofalo. First, we'll go to questions from or staff. We'll start with Commissioner Linton.
Yes, thank you, Mr. Chairman. Just one question. In your recommendation, you noted that you would like to encourage or direct the company to work with staff regarding staff's record keeping and tariff concerns. Regarding the record keeping, is there
I bet you want to know what record keeping I'm talking about, and I'm told that I proposed that language, but I think what we really mean is we want to make sure that we're we're tracking this correctly, and also that it is in sync with the lists that come up. So this is part of the tariff concern.
Okay. Do you foresee any concern when working with the company to address that?
I do not.
Okay. Thank you.
Thank you, Mr. Chairman.
Anything else for staff? Commissioner O'Donnell.
Thank you, Mr. Chairman. So in 2017, there was an overcollection of $133,456, correct?
Correct.
What happens to that overcollection?
So, along the way, I guess the overcollection is being accrued, and it is kept by the company. I don't believe they are earning a rate of return on it, but they would have to answer that. But what's being proposed today is that $133,000 and some dollars be put into a regulatory liability. There it would sit. It would earn interest at the company's rate of return, and probably in a year, really after the company's next rate case is completed, so that their STRIDE projects are put into rate base, and at which point the STRIDE surcharge would drop. That money could be returned to customers according to their class. So the residential class would get back would get back $180,725 plus interest, and the commercial customers would get back $12,834 plus interest.
Okay. And can you cover with me again the spending above the cap on STRIDE and what you're recommending to do with those expenditures?
I think I'm going to need to call on my brain trust here.
Yulia Poboreski on behalf of staff. If your question is regarding the charge itself, the surcharge?
So the statutory cap is $2 per residential customer, correct?
Correct.
So I thought I heard staff say that expenditures will exceed that cap and that they're recommending that those exceedances be placed in a regulatory asset.
Correct.
Doesn't that have the general effect of exceeding the $2 statutory cap?
No, the actual rate that is calculated by BGE right now is $2.66. So it will have to be capped for the customer bills at $2.
Right.
Meaning per month, BGE will not be able to collect more than $2. But the actual rate, whatever is more than the difference between $2 and $2.66, will be deferred until either next year when they come for reconciliation, and possibly it will be less than that, or till the rate case. When they come for the rate case, the STRIDE project will be moved into rate base, and the rate supposedly will fall below the $2. And then when BGE proposes to subtract this overcollection from the charge to make it lesser than the actual charge would have been otherwise.
Got it. And I think we made a decision on that recently, similar, but it's just dawning on me from a legislative perspective. I think many legislators thought that the residential customer would only ever pay $2 per month for STRIDE, but that's true in a sense, but it's untrue if you look at it, like if you pick up the covers and look underneath the covers, they're going to pay it later. It's just deferred for some time.
Yes, absolutely.
And it's accruing earnings as well. Okay, thank you. I appreciate that.
Anything else for staff? Commissioner Herman.
Ms. Garofalo, the staff recommendation is to create a regulatory liability, and I just didn't see in the company's filing, they just said where they have over collections, they're going to track it and include it plus carrying costs in a future STRIDE surcharge. So I just wanted to make sure the company I think that sounds like a regulatory liability, but just make sure that the company is in agreement with that a regulatory liability is being created. And have you spoken to them about that?
I believe we just spoke about it, and they agree, but you should check with them. The accountants tell me it's a regulatory liability, correct?
Yes, when it's over collection, it will be a regulatory. The BG proposes to create a regulatory liability, meaning it will be accruing interest.
Okay, I just, they just didn't, they said they would accrue carrying costs, and I just wanted to make sure they were in agreement with what you got, they were in agreement with what you're proposing. And it sounds like they are. They're nodding over there, and I'll ask them, later, but I just wanted to have, be perfectly clear they were in agreement.
We did want to be clear that it was not a regulatory asset.
Yes, I know. It's a regulatory liability. If I understand that. Thank you.
Anything else for staff? All right, no, they're not going anywhere. So let's hear next from the company, Mr. Herson.
Good afternoon, Mr. Chairman, Commissioners. Daniel Herson for Baltimore Gas and Electric Company. And I brought John Frayne with me, our Director of Regulatory Strategy and Revenue Policy, and he can make some clarifying remarks and confirm some of the answers or address some of the questions that other commissioners had.
Very good.
Good afternoon, John Frayne for BGE. Commissioner Herman, in response to your question about whether the company does agree that what we are agreeing to here is a regulatory liability, we absolutely agree with that. That is exactly what we mean when we say we will track those balances and that they will accrue carrying charges until they get built into a rate for customers. And then I also wanted to clarify for Commissioner O'Donnell exactly what happens with the revenues that are, I'll say, are foregone when we're in a situation where the stride surcharge, as it is today for residential customers, we calculate that it should be $2.66, but due to the cap, residential customers are only paying $2 per month. That 66 cents is truly foregone revenues. We are not tracking those revenues. We're not holding them in a regulatory asset for them to be recovered in the future. Those, due to the cap, are foregone, and we will not start actually being able to recover on those investments above the $2 essentially until we come in for a base rate case, and those can be reviewed and ultimately looked at and moved into base rates at that time.
I appreciate that clarification.
All right, anything else for the company? If not, I want to commend the company for your 2017 stride work. The very small variances in the work, as well as being on time and on budget. So thanks for a good year. We appreciate it. Okay. Is there anyone else who would like to be heard on item 15? All right. If not, do we have a motion?
Mr. Chairman, for item number 15, I move we accept the tariff revisions for filing with an effective date of May 1st, 2018.
All right. I'm sorry. Continue.
Oh, I'm sorry.
No, I apologize for interrupting.
Not a problem. Direct the company to establish a regulatory liability as discussed in staff comments dated April 17, 2018, and direct the company to work with Commission staff regarding staff's concerns with the company's existing tariff language regarding the treatment of imbalances.
Thank you. Is there a second?
Second.
All those in favor signify by saying aye. Aye. Motion carries. I want to thank our Commission staff for a great analysis on this item.
Okay, next item on the agenda is item number 18. It's Columbia Gas of Maryland, Inc. filed its annual stride reconciliation filing and its revised IRS rates proposed to be in effect on May 1st, 2018 as well.
So this is the fifth year of Columbia's stride as well. Its stride plan was approved by Commission Order Number 86553, issued August 14th, 2014. Columbia made its filing on March 15th and updated for various items, including the effect of the recent Tax Act. Columbia performed 16 stride projects in 2017. Overall, the difference between total estimated cost and total completed cost was savings, if you will. It was negative anyway, of 3.7%. Two projects showed a difference that exceeded 50%. These differences are noted with descriptions in page 7 of staff's comments. Staff is not making any adjustments at this time for these variances. All Columbia classes are at the cap. During 2017, Columbia undercollected its stride surcharge. However, there will be no change in the surcharge due to this undercollection because the company is at the cap allowed by law. Staff has reviewed the company's calculations of its proposed 2018 stride monthly surcharge and reconciliation factor and believes they represent accurate rates based on collections through December 31, 2017. Staff recommends the Commission accept for filing Columbia's proposed tariff revisions to be effective May 1, 2018.
Thank you, Ms. Garofalo. Any questions for our staff on this item? All right, if not, we have the company here with us as well. Good afternoon.
Good afternoon. Megan Moore on behalf of Columbia. I just want to thank staff and OPC for working with us on the few times we had to update the filing and with the tax part too. So I have nothing else to add, but thank you.
All right, thank you. Any questions for Ms. Moore? Now, I want to thank Columbia also for its 2017 stride work. All right, anyone else like to be heard on this item? Hearing none, do we have a motion?
Yes, Mr. Chairman, for item number 18, I move that we accept the tariff revisions for filing with an effective date of May 1st, 2018.
Is there a second? All those in favor signify by saying aye.
Aye.
Motion carries. Okay, I'm glad all the controversial items are out of the way. Now we can, now we can go to item 19.
Mr. Chairman, item number 19 is Chesapeake Utilities, filed revised tariff pages. The company proposes a reduction in the delivery service rates to flow through the benefits of the corporate income tax decrease to its customers.
Good afternoon.
Good afternoon.
Janice Flynn for this item. Chesapeake Utilities has filed revised tariff pages to comply with the Commission's order in case 9473. This order directed Maryland Utilities, whose rates are explicitly grossed up for taxes, to make a filing explaining how the Tax Cuts and Jobs Act of 2017 impacts their operations and how and when the company proposed to pass on those tax effects to customers. Chesapeake made several filings, but its April 9th filing contains the most up-to-date calculation of the impact of the reduction of the corporate tax rate. As adjusted, Chesapeake shows that the change in the corporate tax rate has an impact of $262,323 on its operating income and an impact of $209,725 on the amortization of the excess accumulated deferred income taxes, for a total tax savings to be returned to customers of $272 and change. Okay. The staff and the OPC agree with the company's calculations on these amounts. The company has proposed revising rates to reflect these tax savings on the portion associated with the operating income only. The tax savings associated with the ADIT, the company proposes to use to establish a pilot for a sustainable growth program, which would be used to fund the uneconomic portion of a proposed gas expansion project that would address the concerns of either supporting economic development and or expanding service to underserved residents of the Eastern Shore. For the reasons that are stated in staff's comments, staff believes that the tax savings associated with excess accumulated deferred income taxes should be passed on to current customers in the form of lower rates and not redirected to potential new customers. Further, staff does not believe that the sustainable growth program described by the company will meet the NARUC best practices standards for gas expansion, and that the proposal does not follow the matching principle, since its return of the excess taxes, it doesn't return excess taxes to the customers who are paying them. Staff proposes to distribute, Chesapeake proposes to distribute the tax savings associated with the regulatory liability period, that's the period from January to April 30th, to customers in the form of a one-time bill credit, which would be refunded in either June or July. The estimated amount of the regulatory liability is approximately $53,000, which will result in a $3.41 refund to the average residential customer. As the Commission may note, staff filed supplemental comments last week. It did not change staff's recommendation, but noted a potential issue regarding the over-recovery of the excess deferred income taxes under staff's proposed rates. As noted in the supplemental comments, staff's recommended rates were derived by recalculating the rates based on the company's last base rate case. Chesapeake's last base rate case was in 2006, and the company has provided information showing an 85% increase in its billing determinants since that case was completed. Chesapeake indicated that it would not be in a position to file another base rate case for another 3 years, but staff believes that that period is too long and requests that the company file its rate case, a new rate case, as soon as practically possible to firm up these issues. With those comments, staff's recommendation remains as it was in its original comments, and we recommend that the Commission direct Chesapeake to file revised tariff pages reflective of staff's recommended rates with an effective date of May the 1st, authorize Chesapeake to implement a one-time fixed bill credit related to the 2018 regulatory liability, direct Chesapeake to make an informational filing that discloses the actual refunds distributed to customers not more than 60 days after completion of the distribution of the one-time refunds, direct that if additional tax savings are identified that were not addressed in Chesapeake's previous filings in this matter related to the Tax Cuts and Jobs Act of 2017, Chesapeake be required to make a filing with the Commission to return those savings to customers as soon as possible.
Okay, Ms. Flynn, just to be clear, staff's not recommending that the Commission direct the company to file a rate case within the next year. That's just a recommendation.
Right. We're noting this concern to the Commission, but we stop short of asking the Commission to actually make that directive, as we think it is up to the company.
Okay, thank you. Appreciate that. All right, questions for staff before we...
Ms. Flynn, just really briefly, has the Commission in any of the prior filings made any similar decisions with respect to the accumulated deferred income taxes being treated differently than the income tax, than the operating?
No. In all the previous Tax Cuts and Jobs Act filing, excess deferred income taxes are returned to current customers through rates.
Okay, thank you.
All right, thank you. Okay, good afternoon.
Good afternoon. Thank you, Commissioner. Anna Ryan on behalf of the Office of People's Counsel. And as staff indicated, we've been having conversations both with staff and Chesapeake, and we do concur with staff and the company as well on the operating income and regulatory liability issues proposed in this docket. OPC's primary concern, similar to staff, is with the return of the excess ADIT funds to the customers. And we concur with staff, and we support staff's proposal on how these funds are returned to customers. We don't see this proceeding as the proper time for a project such as the Sustainable Growth Program. This is a limited proceeding designed to make it as expedient as possible to get the benefits of the TCJA back to customers so that they're not overpaying. This proceeding simply doesn't give us enough time to conduct the kind of investigation, to put on testimony, or do the lengthy process that results in a good determination about whether or not the Sustainable Growth Program is in fact a good program, and if so, who should be paying for it. That's all something that should be developed in a separate proceeding where the merits of that program could be considered on their own. As a result, we support staff's proposal for how the excess ADIT will be returned to customers. And in addition, we support staff's encouragement that the company come in for a rate case, but we will take it one step further and request that you order Chesapeake to come in for a rate case. As you noted in our last letter that was just filed this Monday, we proposed a date of January 1st, 2019. One of the reasons this case had to be deferred for a week, after having originally been scheduled for last week, is because of the difficulty of determining the best method, the most fair method of refunding the excess aid to customers. And that is the result of the last case having been in 2006 and the massive growth that Chesapeake has experienced. It made it difficult to come up with what is the fairest way to address the benefits of the TCJA and make sure customers are getting those. The only way to make sure that the TCJA benefits, as well as other costs being incurred by customers, are distributed fairly among customer classes is through a full rate case. And so OPC does request that the board order Chesapeake to come in for a rate case.
All right, thank you, Ms. Ryan. Any questions for Ms. Ryan? Thank you very much. And next, let's hear from the company, Mr. Quinn. Good afternoon.
Good afternoon, Mr. Chairman, Commissioners. Brian Quinn on behalf of Chesapeake. Let me just say I want to thank staff very much and OPC for working with us. The reason the filing was delayed a week was for a reason that we have now agreed to, staff's position. But just to back up for a minute, we saw staff's comments last week, and their methodology for returning the excess added. In case you reject our proposals for these expansion programs for Chesapeake and Sandpiper, and you direct us to return the excess added, there was a difference of opinion on the best methodology as to how to do that. I don't need to bore you with our proposal because we never made it, because if you may be confused why there's staff supplemental comments talking about Chesapeake's proposal. We never formally put that before the Commission. In the interest of compromise, we've decided to and I've told staff and OPC this last night, but we decided to just simply accept staff's excess added methodology if you choose to reject our programs. And I won't get into it, but it was an issue also raised by Elkton Gas. But nevertheless, we're fine with staff's proposal. Now, my theme for our expansion programs is, I guess it never hurts to ask. So I hope you'll consider that. And give me a minute to respond, perhaps, to staff's comments and OPC's, if I may. And I understand the posture of this case and what it is. Staff mentioned the NARIC recommendations from the 2017 report about using a robust and open process. All the NARIC recommendations say is commissions should review expansion programs in cases that allow for the Commission to consider a diverse amount of opinions. Anyone could have intervened in this case. Staff and OPC presented us with data requests. On the SGP program for Chesapeake, it's not that complicated a program. It's simply taking a pot of money and using that to fund the uneconomic portion of a natural gas expansion project. That's why we thought it was at least worthwhile to at least ask. Given the NARIC report's other recommendations, which talk about, perhaps Commission should look at targeted expansion programs, another recommendation about, how other states have socialized certain costs of natural gas expansion, given the low cost of natural gas. We just thought it was appropriate to at least bring this program and idea to your attention, given the Washington Gas case and all the other recent developments on natural gas expansion. If this isn't the appropriate form or case for that, that's fine. But I just would point out that this is a robust and open proceeding, and we did answer some data requests. As far as the matching principle, the NARIC report also says if you have any program that socializes some cost of natural gas expansion, there's going to be and benefits potential future customers. There is going to be some mismatch of revenues there, and that's something that the NARIC report and the NRRI report, there's a lot of recent literature on this, and I'm sure you've read about gas expansion projects. That's the reason why the idea is to have commissions perhaps reconsider their views on socialization across customer base for natural gas expansion. And that's why we thought it was at least worth an effort to put this program in this case, and in the Sandpiper program, the CHP case, our reasons are basically the same for both requests. Bringing natural gas to the Eastern Shores is long needed. We're doing it in Sandpiper's territory. We're not as successful in Chesapeake, so we just thought we'd attempt this program here. Now, if you have and the last thing I'll say is about the increase in volumes and billing determinants since the 26 rate case. When we've talked about this with staff, that's mostly as a result of adding some large commercial customers. There's a mushroom plant I think we added. I don't know if you've ever been to a mushroom plant. I never have, but it's pretty neat. Heard it doesn't smell that great, but they use a lot of natural gas. And so a lot of that is volumes related to large commercial and industrial customers that have come online. The residential customer growth in Chesapeake service area, it's been relatively flat. You know, it's the actual amount is 16% since 2006, but that's, you know, over that 12-year horizon, that's okay. So anyway, so if you choose to reject the programs, we agree with staff's proposal to return the excess added in their methodology, and we can move on from there. Just happy to answer any questions.
All right, thank you, Mr. Quinn. How much is the total excess ADIT that the company's proposing to put into the sustainable growth?
Thanks, Mr. Chairman. We agree on the amount, which that, let me be clear, in both companies, we agree on the exact amount, both of the operating income and the excess added IT amount. So the amounts are agreed to. That was the reason for our second filing. It's 209.
I have it, 209,705.
209 and change.
209 and change. And so if that were to go into the sustainable growth program, would that be added to Chesapeake's rate base, or would that be kept out of rate base, that 209,000?
It wouldn't be added. No, we wouldn't earn a return on that. It would, and I've got representatives of the company here who are expert in both programs, but no, it would just be held and used by the company to fund when expansion projects are considered. It would be utilized if there's an uneconomic portion. Instead of charging the SIAC to the potential new customers, it would be used to bring that contribution amount down.
But that would not, that investment would not then go into rate base. Is that correct, or would it go into rate base?
Not until I don't think until we have a rate case, right? Sherry, why don't you come up, if you don't mind? Sorry, Mr. Chairman.
Sorry.
Sherry Richard, who's a regulatory. What's your title? Why don't you introduce yourself? I forgot her title.
Sherry Richard, Vice President, Rates and Regulatory Affairs. The investment would go into plant, but we would have an offset similar to a contribution in aid, so we wouldn't earn a return on it.
Okay, but it would go into plant.
Yeah.
All right. Okay, any additional questions? We'll start with Commissioner O'Donnell.
Would it be fair to say, Mr. Quinn, that the cost of service study, notwithstanding your explanation of where the company's growth has been in commercial and industrial, but the cost of service study that was done in 2006, probably getting a little long in the tooth at this point, just as a generalization?
Yeah, I suppose that's true, Mr. Chairman. Yeah, I suppose I would agree with that. I just only point out Potomac Edison hadn't been in for a rate case for 20 years, and until recently. And last time I checked, not coming in for a rate case isn't a bad thing necessarily. It demonstrates, in our mind, the company's making good decisions.
Right, and I'm not disputing that all, but I am suggesting that when there was a return to the customer classes, the allocation of that return could be a little out of whack if the cost of service doesn't identify those classes appropriately. And so therefore, the monies that are going to be returned in this case may not be going from whom they were paid accurately. Would you agree?
Yeah, Mr. Commissioner, I would, Commissioner O'Donnell. And let me just say, our hesitancy, if at the risk of answering a question that wasn't asked, but it really comes down to a manpower issue with the company. We'll file a rate case. You can obviously direct us to file a rate case whenever you want. But the reason, we're on a 3-year horizon in the company's plans to file a rate case is because of a lot of different reasons. But the number one reason is they have a very small regulatory shop. You're basically looking at it. It's here. And they handle Maryland, Delaware, and the FERC. And we're scheduled to come in for a rate case in later this year for Delaware. We're doing bare steel replacement in Chesapeake's service territory. We're in the middle of that. We haven't finished it. If you're asking why don't they file a stride for that, well, there's a smaller customer base, and the $2 cap on the surcharge and stride really doesn't make that a useful tool for Chesapeake service territory. So there's a lot of reasons why, they're just hoping if you order us in, it would be for not until early 2021 is probably one of the best. I mean, when you ask me, and we can talk with the company before today, I asked them, you've got to consider when we could possibly come in, and that's sort of the time frame they gave me. So those are our reasons, Commissioner. I don't disagree with anything you said.
Yeah, I mean, I appreciate that, and I appreciate the challenges and resources that the company may have in terms of providing the appropriate level of regulatory responsiveness, but I also know that the longer that cost of service study is not allocating costs to the respective customer classes accurately, that goes forward. So all the taxes that are paid going forward under the new rates,
that's right,
may be misallocated to the customer classes as well. So it's not just the return, and the longer that they stay out, the longer that any misallocation that does exist is going to continue to occur. Thank you.
Commissioner Herman.
Thank you.
Mr. Quinn, with respect to the gas expansion plan, I appreciate the creativity and the effort. And I think, though, at least for my part, I think it's just not fleshed out enough. We just wouldn't understand enough about it. I think there may be some, while this is indeed people have the opportunity to go and look and see what's happening on the Commission's website, it might not have triggered some others who might have an interest in this kind of proceeding. But I do appreciate the effort.
Thank you.
Thank you.
Any questions? Yes.
I would also add to Commissioner Herman that I appreciate very much the I'll call it creativity or the interest in gas expansion. As you well know, that is a policy that was expounded by the Maryland Energy Administration, by the state, as something they would like to see happen. And generally, the Commission was supportive of that in the last in the merger case. So I would just encourage the company to continue and work with the Energy Administration to look at some of the NARUC report recommendations and how perhaps we can take a look at our economic test here in Maryland to see if we can, at least for our role here, how we might support whatever Energy Administration is going to propose.
100% agree, Commissioner Richard. And in fact, we have been meeting with the MEA over the last year and a half now, talking about Chestertown and areas that they're interested on the Eastern Shore, trying to work out programs and proposals that would get gas to certain areas. And I know I'm on speed dial with Mr. Fiastro. I know him well, and we've had some very good meetings and discussions with him, and we'll continue to do that.
Very good. Thank you. Ms. Flynn, any final comments?
I think we have it covered.
All right, thank you very much. I want to thank Mr. Valcarengi and Ms. Ward for their analysis. The issue is before us. Any discussion? Not, are we ready for a motion? Okay. Whose turn?
Mr. Chairman, I move we direct the company to file clean copies of tariff pages that reflect staff's recommended rates listed in Exhibit 3 of staff's comments dated April 11, 2018, with an effective date of May 1st, 2018. Direct the company to implement a one-time fixed bill credit related to the 2018 regulatory liability. Direct the company to make an informational filing with the Commission that discloses the actual refunds distributed to customers not more than 60 days after completion of the distribution of one-time refunds. And finally, direct the company to make a further filing with the Commission as soon as possible if additional tax savings are identified and not addressed in the company's previous filings in this matter related to the Tax Cuts and Job Acts of 2017.
Is there a second?
Second.
All those in favor signify by saying aye.
Aye.
Motion carries.
Mr. Chairman, last item on the agenda is item number 20. It's Sandpiper Energy, also filed revised tariff pages. Again, the company also proposes a reduction in its delivery service rates to flow through the benefits of the corporate income tax decrease to its customers.
Thank you, Janice Flanagan, for this last item. Sandpiper's filing is similar to Chesapeake's, but it does raise several unique issues. First, the pass-through for operating income savings is approximately $500,000, and the pass-through for the ADIT is it's $209,993. And Sandpiper again is in agreement with these amounts. Like Chesapeake, Sandpiper is proposing to use the excess ADID savings to establish a separate program rather than returning the amount to customers. In this case, Sandpiper is suggesting using the savings to provide grants to customers to defray the cost of installing a combined heat and power combined heat and power incentive equipment, or a CHIP program as a pilot. Staff does not agree with this diversion of funds to this select group of ratepayers, and for the same reasons that we stated in Chesapeake, believes that the ADIT amount should be returned to current customers, as we suggested in Chesapeake, and using the same system. The Sandpiper doesn't present the same calculation problem with the excess ADIT. Sandpiper has had a rate case more recently. In fact, Sandpiper is in the second year of a 6-year settlement of its last rate case, which is case number 9410. Pursuant to the settlement agreement, rates are revised annually based on the projection of converting customers from propane to gas. Exhibit 2 of staff's comments details the change in rates for year 2 of the settlement, and staff is recommending that the company be directed to update the settlement rate sheet showing the effect of the Tax Cuts and Jobs Act for years 3 through 6. So with those unique points for Sandpiper, staff recommends that the Commission direct Sandpiper to file tariff pages reflective of staff's recommended rates with an effective date of May the 1st, 2018. Direct Sandpiper to file an updated case number 9410 settlement sheet showing the effect of the Tax Cuts and Jobs Act for years 3 through 6. Authorize Sandpiper to implement a one-time fixed bill credit related to the 2018 regulatory liability. Direct Sandpiper to make an informational filing that discloses the actual refunds distributed to customers not more than 60 days after completion of the distribution of the one-time refunds, and direct that if additional tax savings are identified that were not addressed in Sandpiper's previous filings in this matter related to the Tax Cuts and Jobs Act of 2017, Sandpiper be required to make a filing with the Commission to return those savings to customers as soon as possible.
Thank you. Any questions for our staff? Not, Ms. Ryan.
Thank you, Anna Ryan for the Office of People's Counsel. In general, OPC would concur with staff's comments and recommendations. Again, in the Sandpiper case, OPC's primary concern is with how the benefits of flow back to customers from the excess added. I'll simply reiterate OPC's comments regarding the Chesapeake proposal, but would like to add one additional point with respect to Sandpiper's proposal, which is that the combined heat and power program would not even apply to residential customers. They wouldn't be eligible for it. As a result, there would be an even greater mismatch in this case between who's paying for the program and who's benefiting from the program than there would have been in Chesapeake. That's the only additional comment I'll make.
Thank you, Ms. Ryan. Mr. Quinn.
Now, this is completely different, Mr. Chairman. Thank you, Mr. Chairman. Brian Quinn on behalf of Sandpiper, Chairman and Commissioners. You don't like one expansion project, I'll raise you another. Yeah, let me just address it. Just again, not much different to say, other than our thought on the CHP program, which again isn't an unusual concept, and MEA actually has a CHP program, Commissioner Richard, as you know. We were hoping that the CHP, in addition to all the other benefits that it has, securing the grid, the customers could act as anchor customers, and with that they could encourage the load necessary to extend service to residential customers. So that was sort of our tie-in to between the CHP customer and the residential. I understand if this isn't the appropriate lane for that proposal, but that was sort of our thought. If the Commission chooses to reject this proposal, we, again, want to thank staff and OPC for all their work. It's been a pleasure working with them, and we would accept staff's excess added methodology, which doesn't present the same issues here. In the Sandpiper settlement, the good news is rates are going down. They're going to continue to go down for the next 4 years, and we're actually under an order in the settlement to come in for a rate case at the later of converting 80% of the customers, or 6 years, and that 6 years is up in 2022, I believe. So that's really all I have. Happy to answer any questions.
Thank you, Mr. Quinn. Any questions for Mr. Quinn? All right, not, thank you very much.
Thank you.
Okay, the issue is before us. Any discussion before we take up a motion? Not, do we have a motion?
Mr. Chairman, I move we direct the company to file clean copies of tariff pages that reflect staff's recommended rates listed in Exhibit 2 of staff's comments dated April 11th, 2018, with an effective date of May 1st, 2018. Direct the company to file updated Class 9410 delivery service revenue schedule for years 3 through 6, paren item 1, page 3 of the stipulation and settlement, end paren, that reflects the impact of the Tax Cuts and Jobs Act of 2017. Direct the company to implement a one-time fixed bill credit related to the 2018 regulatory liability. Direct the company to make an informational filing that discloses the actual refunds distributed to customers not more than 60 days after the completion of the distribution of one-time refunds. And finally, direct the company to make further filings with the Commission as soon as possible if additional tax savings are identified and not addressed in the company's previous filings in this matter related to the Tax Cuts and Jobs Act of 2017.
Is there a second?
Second.
All those in favor signify by saying aye.
Aye.
Motion carries.
Thank you.
I want to thank again Mr. Valcarengi, Ms. Ward for their analysis on this item. We are adjourned.